Picture this, you've been searching for a home for months, even years. Even before COVID, you've been searching for a home and you find the perfect house in the perfect neighborhood. Wraparound Porsche, eat-in kitchen, beautiful backyard, pool. You're under contract, you're excited, you apply for your mortgage, you finish your appraisal, you finish all your inspections, and then the seller wakes up one day and says, I'm not selling it. What do you do? Today I'm going to talk about what you do if you're in that situation. So in order to understand the fundamentals of breach of contract, you need to understand the fundamentals of a contract. You have offer, acceptance, and consideration. You submit an offer through your realtor, the seller countersigns it, they accept your offer, and now you're in attorney review. During this process, presumably two attorneys, the buyer's attorney and the seller's attorney, will negotiate certain aspects of that contract. Once all the parties agree on those conditions, the contract will be out of attorney review, meaning that the seller cannot now market the property to other buyers. If for whatever reason the contract is still in attorney review and the parties are not out of attorney review, the seller can actually accept another offer and cancel the contract while they're in review with you. But let's just say for argument's sake that the seller accepted your offer, they signed off on review, and now the contract is firm, meaning no other buyers. I can tell you in most situations where a seller arbitrarily cancels, there's typically some underlying reason for that, but the way the market is today in 2024, a lot of sellers are just happy to get the money that they're getting for the house, so I don't see it as often as I used to. If you're in a situation where the seller no longer wants to sell you their home, you have options. Your main option is to file something called a specific performance lawsuit, and that is done in the Chancery Division of the Superior Court in the county that the property is located. So if the property is located in Ridgewood, New Jersey, that's Bergen County, your attorney would file a specific performance action in the Chancery Court of that county. One important thing you should know is that the attorney who's representing you on the transaction cannot represent you, for the most part, on the specific performance action. And the reason why is that your attorney is now a witness to the case. He or she is the one that reviewed the contract, they negotiated the attorney review riders and addendums, and they can testify to the facts surrounding conclusion of attorney review. Again, that's for the most part. There are specific situations where the attorney who represented you on the transaction may represent you in the litigation aspect of it, but I can tell you from experience, most transactional attorneys, not myself, but most, do not practice litigation if they practice transactional work. So your best course of action is to get a referral from the transactional attorney for a litigation attorney who can represent you on that specific performance lawsuit. So what's a specific performance lawsuit? A specific performance lawsuit is much simpler than it sounds. As the moving party, which would be the buyer, you're telling the court, I have a seller who agreed to sell me their home, we're under contract, most of the contingencies are resolved. In a specific performance action, you're simply asking the court to force the seller to sell you the home. And the reason why is because in New Jersey, there's a law that says that no two properties are alike. And that's true. We're a small state, we're a very old state, so a lot of the properties are older. And if you find one property on one street in a town, you will most likely not be able to find that property either in that same town or even close. So no two properties are alike. It's unlike the Midwest where you have areas like Texas, for example, where there's huge subdivisions and they build 50, 60, 70, 80 homes, and they're all just different versions of each other. If you find a home, let's just say in that Texas subdivision, and the seller decides not to sell it to you, well, maybe there's a home that's similar in the same subdivision. And again, I'm not speaking to Texas law, but there could be a situation where the home that you find is very similar. I'm not saying you wouldn't have a case against that seller, or you wouldn't have a case for damages if that home costs more, but it's different than New Jersey. New Jersey is very unique in that sense. And it's one of the main reasons why in New Jersey, it's standard for most parties who are buying or selling to have an attorney, because that attorney needs to review the title work, they need to review the surveys, they need to help negotiate the contract and the riders. It's very unique. It's not like other states. For example, Florida, it was common practice for a long time that they wouldn't have an attorney represent them. It's starting to get better now. I see a lot of Florida transactions where they're using attorneys, but New Jersey is very unique in that sense. So you're essentially going to the court and you're telling them that I need this seller to sell me the home, and if they don't sell me the home, I will face something called irreparable harm, meaning I can't find another home like this for the same price, in the same area, on the same block. I mean, it's very specific. When choosing an attorney to file a specific performance action on your behalf, it's very, very important that you choose an experienced attorney who's done it before. I say this because the paperwork that's required to file a specific performance action, although You're asking the court for something simple. It's a bit complicated. You need to show the court that there was a valid contract. You need to show the court that the contract properly described the property, that there was consideration, that there was offer, acceptance, everything that we talked about before. And then your attorney needs to go into the case law and the standards behind a specific performance action in New Jersey. The standard for a specific performance suit is you need to show the court that you've been harmed, and the only way to remedy that harm is to force the seller to specifically perform on that contract that they breached. Simply put, money damages are insufficient. It's not like a lawsuit where somebody owes you $100,000. Your lawsuit is, you owe me $100,000. You can't place a money value on the seller's breach. Now, I will briefly talk about something called liquidated damages. That has to do with commercial transactions. In commercial transactions, I have seen in many commercial transactions something called the liquidated damages clause. And it essentially says that if either party breaches the contract, they agree to a specific amount ahead of time. So I'll give you an example. Buyer's under contract to buy a property, it's $1 million. They put down a $100,000 deposit. Seller says, if you breach this contract, because I cannot determine my damages or it'd be too difficult to determine damages, I get to keep your $100,000. The reverse of that. Buyer says that if you decide to no longer sell me the property, now you owe me back my deposit plus another $100,000 as liquidated damages. Outside of that, outside of the liquidated damages or some type of mutual agreement in the contract where both parties agree to what damages will be, there is no monetary remedy outside of specific performance that the buyer would be entitled to make them whole. Let's say your attorney files a specific performance lawsuit, the judge agrees, it goes through the court, an order is entered to force the seller to sell you the home. Typically what will happen is one of two things. The judge will give an order saying that the seller is now required to sell the home to the buyer and that the buyer must cooperate in good faith and that the seller must cooperate in good faith. There are specific situations where you have a seller who refuses to sign paperwork, who refuses to sign the deed and the corresponding paperwork with it in order for the buyer to effectuate the closing. In limited situations, the court could appoint somebody who could sign as attorney and for the seller. So in those situations, the court would have the authority to force the seller to essentially have someone sign on their behalf. So you won. You have a piece of paper that says that the seller has sold you the home, your deed is recorded, but the seller's still in the house. Now what? You would have to file something called an ejectment action. That's different than a landlord-tenant action. A landlord-tenant action is between a landlord and a tenant. An ejectment action is essentially saying that the person occupying the home doesn't have the authority to be there. It is a little nerve-wracking now that you own a home, the seller's still living in it. You still have to go through the ejectment process to get the person out of the home. In some situations, the judge might put in the order that the seller has to vacate the home, but in the majority of the situations that I've seen, the court requires a separate ejectment action. I think it's important to know that there are defenses to specific performance. The seller does have a right to respond to your lawsuit. So typically what I've seen is one of two things. The seller either comes back and says, no, we do not have a valid contract. You either breached the contract or the contract was rightfully terminated. If there's no contract, then you don't have a right to file a specific performance action. If the seller prevails on that defense, then you have a big problem. I've defended many specific performance actions. Typically, your best bet is the kitchen sink theory, which is throw every single defense you have against the wall, see what sticks. If the seller proves that the contract was rightfully canceled, meaning a certain time period passed, or the buyer didn't get their mortgage commitment within a certain period of time, and the seller effectively terminated, or if the parties couldn't agree on inspection terms and the seller effectively terminated, then you pretty much lose your case. The other defense to that is, hey, you're in the wrong court. You don't have to file a specific performance action because money can remedy the breach. You have to be careful with that defense because you're essentially admitting that there was a breach. So typically, I don't like to use that defense, but I have seen it where attorneys will file a response and say, hey, you can be remedied by money. You don't need to force the seller to sell you their home. There are other avenues where you can be made whole. But like I said, that first example I gave where the seller says you breached the contract, you don't have a right to be here, that's typically the best bet. Now, that's another reason why it's very important that the attorney you choose to file that specific performance action is experienced, because he or she can kind of anticipate that type of defense and draft a complaint that is incredibly fact-specific, it's detailed, it meets all the standards that the court is looking for, and it can get in front of a judge quickly and efficiently to protect the purchase of your home. I want to talk about some issues with filing a specific performance action that a lot of people don't realize. Number one, the wheels of justice turn very, very slow. Just because you file an action does not mean that the judge is going to drop what they're doing, review it, and say, oh my God, they found their dream house. We need to close right away. No, it has to go through the process. That means a delay in your mortgage. That means a delay in your rate lock, meaning most banks, when they lock your mortgage, they give you a certain period of time. So I'll give you an example on a case that I have as we sit here today. I filed a specific performance action. It's been 3 months. There's been movement, but not a lot of movement. My client now has to let go of their lower rate, and they now need to relock at a higher rate. What does that mean for the buyer? That means that their mortgage payment is going to be more. That means that the amount they pay into their mortgage over the course of 30 years, which is their loan length, is going to be more. A lot of clients ask me, well, now what? That can be part of your damages. When I submit these specific performance complaints, I do ask for damages, and you can ask the court to award attorney's fees and damages. Part of damages are, what is your cost due to the seller's delay and due to the seller breaching the contract? When the seller breaches, that's a ripple effect. It delays everything. It delays moving. It delays your mortgage application. And another thing you have to remember is that your mortgage application expires. So before you do anything, I always recommend with my clients, have a conversation with your mortgage lender. Can you afford the new rate after expiration of your application? Can you afford the new payment? And if the answer to that is no, then the entire process might be moved. Make sure that you hire an attorney that's experienced with filing these type of actions, because they're very complicated. Make sure that before you do this, you have a conversation with your lender and you have a conversation with your attorney as to expectations, and you have to be aware of the timeline involved with filing such an action. If you like this video and you want to see more, comment down below. Otherwise, hit the like button, subscribe, and I'll see you on the next one.